Good morning, everyone. We're going to wait maybe another minute just to give a chance for everyone to join. Okay, good morning, everyone. My name is Ahmad Saleh. I'm partner and head of innovation and patents at Al-Tamimi & Company law firm. And I'm joined this morning by my partner, Martin Heward, head of digital and data at Al-Tamimi. So we're delighted to present today a very important topic and a very trendy topic, and a topic which will remain trendy, for the upcoming, at least next couple of years, with a very speedy development in this sector. We're discussing the FinTech, the financial technology, protection of FinTech, and certain legal considerations with respect to financial technology, protection, commercialization, data protection, and so on. A very quick introduction about Al-Tamimi & Company. I will not take more than 30 seconds. As most of you know, Al-Tamimi & Company is the largest law firm in the MENA, in the Middle East, and we have so far 16 offices in 9 countries with more than 450 legal professionals working across a number of departments in different sectors. Kicking off the presentation, so what is FinTech innovation? FinTech innovation, as most of you know, is about financial technology. So technology which is there to facilitate financial transactions, and it can be of different nature. I'm going to present here quickly just a quick diagram which shows the different stages how FinTech, a FinTech technology is between the design stage, the protection, and the commercialization stage, so that it provides a good visualization where IP protection fits within the process of designing and developing and commercializing a FinTech innovation. So normally, at the beginning of that process, of course, one team, whether it's in a bank, a financial institution, or a company, a startup, a technology company, they start to, they think about a challenge, for example, they want to solve. They start with the ideation and the concept design. And this is a phase which can take a couple of weeks or a couple of months, depending on the technology. So normally, once the concept design is clear for the team, IP protection can kick off already at this concept design stage. Once the concept is clear for the team, and this is before the implementation of the concept in terms of code development or technology development, and so on. So at the ideation stage, once the concept is clear and ready, and when I say concept, it should be clear with respect to how this concept can be implemented. Normally, the technical team comes up with flow charts, for example, to explain the different, how the process works from the process perspective, how the data is being input to the system, how it's being processed, what is the output, how does it interact with other components. So once this is clear and there is a flow chart, a block diagram, how the different components interact together, and so on, and ready for implementation, already at this stage, the team can consider and should consider patent protection for the concept itself. For patent protection, you don't really need to have the implementation already done or have the software code already developed or have the technology already working. Already at the concept stage, you should actually consider patent protection. And patent protection is one, you can seek patent protection, and it's not available all the time, as we will be discussing further, but when you can acquire it and get it at early stages, it is best before any disclosure of the concept externally. And then as you go on in the technology development, the software financial technology comprises an important component related to a software. So as the code being developed, normally copyright is comes to birth automatically by the effect of the law. However, what is important already at that stage to have proper agreements with the people who are developing the technology, whether it is internal or whether this team is external, and to have appropriate confidentiality agreements in place, appropriate provisions in the development agreements in order to ensure that the IP rights go for the right party. So if you are the owner of this technology, if you're a financial institution or a technology company who's hiring people to develop, or you're outsourcing, for example, a part of that, you need to have really agreements in place to make sure confidentiality is preserved and IP protection, IP rights go to the to you as owner if this is the agreement with the developer at the least. So once you get a product in place, normally, for example, let's say this product is for example, a payment mobile application, let's say. There is, of course, already a patent application can be put in place already at an early stage, which is always important to remember before any disclosure of the invention. There is copyright, of course, associated to the application. At least the source code should be protected by copyright. And if there is a design for the, for example, the interface, the user interface, or the graphic user interface of that application, the protection can be considered, for example, through industrial design application. And it's important as well for industrial designs that protection is considered before this application is exposed to the public, because industrial designs, as much as patents, need novelty to be able to be protected. So if you put it to the public before protection is sought, it can compromise. There is a small caveat which we will discuss throughout the presentation. So once this is done and you've considered IP protection, you have your product, then commercializations come in place. And here there are different types of commercialization, whether you are exploiting yourself, whether you are licensing out or other. This is something that we will be discussing throughout the presentation as well. So speaking about IP protection of financial technology, what are the different vehicles or ways or tools you can use to protect a financial technology? Financial technology normally has a component, an important component, which is a software component. And the software component is there to take certain data as input, process it, and then take certain, have an output in terms of actions which will be conducted. So when we look at this, so there's a software component, and in many cases there is a hardware component as well associated to that, interconnected with the software component. So there's a firmware in most of the cases, a firmware, which is a combination between hardware or a physical device and a software. So patent protection, of course, can be considered to protect financial technology. Normally, patent protects the innovative, the inventive contribution of the financial technology. So it's there, and it's an extremely interesting vehicle, and one of the most valuable vehicles, actually, if not the most valuable vehicles, when you can get it, okay, which protects the innovative concept in itself. So we try by patent protection to capture the innovative concept of the financial technology. And normally there is an important part which relates to a process, a computer implemented process. So the way the data is being processed in order to conduct the outcome, which is normally a financial transaction, for example. So patent protection should be considered for that purpose. Industrial designs are there to protect some visual features of the product that you have, and this visual features can be, for example, visual features of a physical device, like, for example, if you take a payment card, for example, it has, let's say, a layout design, which is, you want to protect this. Industrial design can capture that. Or if it's a mobile application, for example, the graphical user interface can also be protected in some countries through industrial design as well. So visual features associated to the financial technology can be captured by industrial design. Normally, these ornamental features or visual features or visual appearance do not have functional use. When there is a functional use for these, and these are novel, it goes more under a patent. So industrial design is there to capture visual features which normally do not have a functional use, and it's purely there to provide a visual appearance of the product. Trade secret is another very important vehicle for financial technology. And why? Because the software component in the financial technology is dominant. So normally you have extensive work in relation to the software code, and as well as the algorithm within the software code. So when you come up with an algorithm, for example, in order to you put in place an algorithm which makes this financial technology more efficient than others, or different than others, or more unique than others. And this algorithm, for example, can have complex mathematical formulas inside it, or can relate to artificial intelligence, for example, machine learning or whatever. Normally, this algorithm is extremely valuable for the technology, to give this competitive edge to that technology. And this algorithm, it's best, sometimes it's best protected if it's kept secret and confidential, so it's not disclosed. So even when we go and we protect a patent, we protect certain components under the patent, we normally pay a lot of attention to any information which should be kept secret. So there's a balance which should be done between patent protection and trade secret protection, in the sense that it has to be strategically considered which components should go under a patent and which components should remain strictly confidential and remain protected under trade secret. And as you know, the new industrial property law in the UAE, it regulates trade secret protection. We're going to discuss a little bit about this throughout the presentation as well. So there's a balance to be done between both, and trade secret is another extremely valuable vehicle for the protection of financial technology. Copyright is another vehicle of protection, which is there and arises normally automatically, protecting the expression of the code, the source code. In this specific case, speaking about the financial technology and with dominantly a software components. So copyright, when you write a code, the source code, this expression of the source code is protected by copyright, and this is normally automatic. Now, in some countries, copyright might be required to be registered in front of the relevant authorities for enforcement purposes. So if we go to the court, for example, someone is infringing on your financial technology, and we need to sue that party. So if we want to use the copyright as one of the grounds in some countries, including in the UAE, normally copyright needs to be registered in front of the authorities. And when we do that, we are extremely careful as well, because when you want to register a copyright, normally, and this depends also on the countries, what are their procedures and requirements. But normally a copy of the source code is required, to give it or to submit it to the copyright office. But when you do that, you are disclosing to the authorities or to the copyright office this. Now, it's important that consideration is given to any confidential information which is part of that source code. Because if, for example, that source code contains some important information about the way or the secret sauce or the secret recipe of the financial technology. I spoke about algorithms. So in terms, for example, of the algorithm and the complex mathematical formulas doing the, which are important to bring this, this innovative contribution to the financial technology. This one should remain secret, shouldn't be disclosed. So how the submission of the application for copyright registration should be taken into, should take into consideration this aspect. In some countries, like in the United States, for example, it's possible to hide some information from the source code. So, and there are, in some offices as well, for example, they permit, if the source code is voluminous, to submit only, for example, the first 50 pages and the last 50 pages of the source code, and so on. So there are ways in order to take into consideration to keep whatever information you need to keep secret without submitting it along with a copyright application. in some countries. So this needs to be taken into consideration as well. So these are the four main vehicles which can be used to protect a financial technology. And normally, when these are considered, they are considered all simultaneously based on the nature of the financial technology and the contribution, the innovative contributions which are made through this financial technology. Speaking about patents, patents, as I mentioned, protects the aims to protect the inventive concept of the financial technology and to capture it in a way which can be presented under a patent application. So normally, as I mentioned, we capture the computer implemented process of how the data is being processed by the processing unit. And this needs to be novel. To apply for a patent application and get granted a patent, you need to have an invention, and the invention needs to be novel. So no one has disclosed this in the past or came up with this in the past. And it has to be not inventive, meaning it shouldn't be obvious. It's not like you're making only one small, feature, which is, very trivial, and you want to get an invention for that. So the contribution should not be obvious in view of what already exists. And it has to be, of course, useful. Useful, it means it has to have practical application. So for a financial technology, traditionally, the eligibility for patent protection of financial technologies, it took, a different path. In the United States, for example, in the 90s, it was open for the protection of e-commerce, and it was more open. It was open for a lot of financial technologies to get patent protection in the United States after certain years. And I remember in the early 2005, a Supreme Court decision came to close the door to, a lot to e-commerce, to the patentability of e-commerce innovations and financial technologies as well. So it made it more difficult for these to get patent protection. And then in 2013, there was another decision in the Supreme Court, which made things a lot more confusing. But today, things appear to be changing with more appetite for the USPTO to accept the patentability of financial processes and technologies, but provided, of course, they meet certain criteria, eligibility criteria. And so when we prepare a patent application to cover a financial technology, we take into consideration this aspect. And depending in which country you want to protect, there are some countries which have more appetite than others for the protection of these. So this needs to be taken into consideration. For patents, registration is required, meaning that we need to submit a patent application to the patent office. It needs to be examined. The patent office examines the application as to the different criteria we discussed: novelty, inventiveness, utility. And once it's accepted, after back and forth normally with the patent office, until we get to an agreement with them, a patent is granted. And when it's granted, you get a protection for 20 years normally from the filing date in the country where the patent has been granted. And so patent is a territorial protection. It only protects you in the country where you've submitted your patent application and where you've been granted a patent by the relevant patent authority in that country. So these are the patentability criteria we discussed. Adding to that, normally public moral and Sharia, and for example, if you come up with something which relates to gambling in the UAE, for example, you might face difficulties with that. So the invention needs also to be compliant to the public moralities and Sharia in many countries in the region here, in addition to the other conditions we've discussed. Now, eligible subject matter, the invention needs also to comply with eligible subject matter criteria. There are certain subject matter which cannot be subject to patent protection for public policy reasons. We're going to discuss these briefly. So normally what you can get through a patent protection, you can protect a product, a system, device, data process, which we discussed. A model in itself, a financial model in itself, it is not subject for patent protection. So if you come up with a model and you want to get it protected by a patent, that's not possible. So normally what we do, of course, your invention, I mean, whatever your financial technology is, many cases you have, a financial way of doing things or a financial model underlying, but however, this is not what we protect the model itself. We protect how the data is being processed by the processing unit and taking into consideration, of course, the financial model that you put in place. The ways to do that, but the financial model in itself, you can't get a protection for a pure financial model. Neither for a computer program. And if you have your software on a CD, this is not patent protection. This is not, I mean, you can't get a patent protection for the computer program per se. So you can't, the computer program, what you can get a patent protection for is, as I mentioned, the computer implemented the process or a system or a device, for example, if it relates, if there is a device involved as part of the financial technology. Computer program normally is protected through copyright. If someone takes your computer program, if you put your software, for example, and someone copies and produces this, it goes under copyright infringement. If someone, if you have your financial, for example, technology material, the software and the information you've kept apart confidential in your, for example, computers, and an employee steals it, for example, or leaks it out without authorization, there is a trade secret infringement as well, in addition to any reproduction of the software code, which might involve copyright infringement. However, this is not patent infringement. Patent infringement occurs when you have a patent issued in a country in relation to your technology, and someone infringes over this patent and doesn't need to take your computer program or doesn't need to breach in your premises for patent infringement to occur. If they reproduce your invention, which is patent protected, whether it's a device or whether it's a process, a computer implemented the process, even if they come to this independently and they develop it independently, they're still infringing over your patent if you have patent protection. Abstract ideas, if you have an idea of doing something, an abstract idea is not something which is protectable under the law. And a mathematical model as well is not something which is can be patent protected. Mathematical formulas cannot be patent protected per se. Okay, of course they can be part of the algorithm, which can be part of the computer implemented process to protect. And it's a strategic choice for us if we involve it as part of our computer implemented invention to seek patent protection, or we leave it outside if we don't need it confidential, okay, so that the secret recipe no one access to. And if you keep it on as confidential and you take the measures to keep it confidential and it's subject to trade secret protection, and a breach of that in the ways we'll see a little bit later can lead to trade secret infringement. So business model per se, it's not something which can be protected and under the law for public policy reasons, because as you know, governments love to keep open the business competition in the market. So this is for public policy reasons. You can come up with a new business model and say, I want to protect the business model per se. So the way of doing business. So for patent protection, you need a technical character or contribution and not a pure abstract idea, as we mentioned. And the computer implemented methods are formed using the software normally, sometimes in interconnections or in communication with other components. And we really here to protect the processes as mentioned. So, and how we approach patent protection and what parts we protect, sometimes we get from the machine perspective, how the data is being processed, or sometimes we take it from the user perspective. So how the user is interacting with the technology and how the technology is reacting in communication with the user to provide the outcome of the which is aimed. So, and in many cases we try to cover the different perspectives. So from the machine perspective, how the data is being processed, and from the user perspective, how the data as well is being exchanged and processed to provide the experience or the outcome required for the users. So in financial technology, these are some dominant innovation types which relate to FinTech, as which are protected normally, which are applied for protection under the patent regime. So normally you have fundamental platform and methods, and you have functional technologies which are there to use the fundamental platforms. So this is normally in digital technology in general, and as financial technology is normally a digital technology, so it follows along the same or similar lines. So normally you have a fundamental technology, for example, for digital technologies, which can be machine learning or neural networks. And these have been protected in the past by entities who came up with these fundamental platforms. Now, for example, if you use a financial technology, if you come up with a financial technology which uses blockchain, there are certain fundamental platforms in relation to blockchain which are already protected. So this is not the protection you're seeking today. Even if your financial technology is using blockchain, so what we want to protect is that application in itself, in the way it uses the blockchain. And in many cases, blockchain is an enabler, enabling you to build something which is doing something different of traditional financial technologies, because it has been enabled doing that specific thing using this fundamental platform, which is, for example, a blockchain now. So we look for that application to protect it, and not the fundamental platform in itself. Okay, unless you come up with a fundamental platform so others can build over it. In this case, the protection goes for the fundamental platform. So this is kind of some examples which I pulled out, just to give a flavor of patent, an example of patent protection of financial technologies. PayPal has been active in filing and getting some patents with respect to their payment technologies, for example. And PayPal is, as you know, it's a technology company, but many banks as well have sought and went after patent protection for financial technologies as well. This is some interesting statistics we pulled out as well to show how patents are being used to protect financial technologies. So here, FinTech patent filings increased 20 times between 2007 and 2018, which shows a little bit the importance of, seeking patent protection for financial technologies. As well, that the trend of the market developing, of course, new innovations and inventions with technical characters related to financial technologies. 85,400 FinTech patent filings between 2017 and 2021, which is substantial, which is very good, knowing the fact that traditionally financial technologies or financial, let's say, methods were more associated to business methods in some countries, like the United States. So in the US, traditionally, many financial methods-related innovations were rejected as being assimilated to a business methods, which do not have technical characters. So things, as I mentioned, have been changing in the United States, with more appetite today for accepting financial methods-related innovations, provided, of course, it needs to meet certain requirements and have technical characters and so on. Of course, it's not as easy as protecting a mechanical device. A mechanical device, we don't. It has to be novel, inventive normally, and we don't look at whether it has a practical application or tangible application or physical application, because it's a physical product. It's not the case for financial technology. Normally, it needs to have a technical character, and we need to bring this technical character out in the patent application when we prepare. Top filing countries for financial technologies in patent, according to our research, showed USA and China. So this is a little bit what I mentioned with respect to the patentability. Now for copyright, and I have discussed this as well briefly. Normally, the scope of protection for copyright in relation to the financial technology, and speaking about the dominant component here, when it's a software inside, is limited to the expression of the source code. So let's say, for example, someone else, you came up with a financial technology, someone else looks at it and says, well, it's fantastic, I want to go and develop something independently. They go develop something independently, they run it, and compete with you. Okay, can you stop them using copyright? Normally, it's no. Okay, if they produce a copyrightable material, okay, or infringe your copyright in any manner, you can't stop them using copyright. Not because they took the concept, you can stop them using copyright. You can't stop them using the copyright if they took purely your concept without reproducing a copyrightable material such as the software code. Okay, and normally, nowadays, with all the capabilities in coding and the modules, the coding modules which are out there, it's it's rare that someone really reproduces exactly your code or takes a part of your code. So normally they look at the concept and they try to come up with something similar. That's why patent protection is becoming increasingly important, to be able to protect the concept, the innovative concept, so to stop these kind of people who don't necessarily reproduce the code in itself. Of course, if someone takes your code and reproduce it, you sue for copyright infringement. If an employee takes a part of the code and leaks it out and starts reproducing it in another system, of course, there's a copyright infringement there. And there are many other examples where copyright infringement can be used, and it is, of course, a valuable tool, but shouldn't be used exclusively, and other tools such as patents should be considered to be able to capture the innovative concept of yours. Now, of course, a copyright term is longer than a patent term, where patents live for 20 years. Copyright normally lives for the lifetime of the author plus 50 years or 7 years, depending on the country, 50 years in the UAE. And registration, as discussed, normally you don't need to go and register your copyright to have copyright protection. So normally, it arises automatically from the time you created the source code, and registration it's useful in cases of enforcement in some countries, or required in some countries. So this is a little bit, to relate the copyright protection to the expression of the code itself, which is important, to know the distinction between patents and copyright in that respect. For trade secrets, so information, technical information, know-how, or business information, which is kept secret and by an entity, and which provides a commercial value derived from its confidentiality. Because it's confidential and no one has access to it, okay, there's a commercial value of that. And you've taken all the measures to keep it confidential. With employees, with them sign confidential information, any external party to whom you give access to for any reason, they sign confidential information, you keep it in a secure place, you've taken the measure to keep it confidential, that arises automatically as well. You don't need to go and register for trade secret protection. So you take the measures to keep it confidential, and normally, something which you want to rely on trade secret protection for that, it shouldn't be subject to reverse engineering. In mechanical products, for example, we rarely rely on trade secret protection in general, because mechanical device, if you put it on the market, someone can open it and see how it's done. So they can reverse engineer it. And when they reverse engineer it, you lose all the protection related to trade secrets. Because trade secrets will provide you with the protection as long as they remain confidential. And this is your job and your obligation to do that. If someone comes to that independently through research, for example, or reverse engineered their product and came up, with the formula or with how it's done, you lose the protection. You can stop them. Okay. Now, of course, if someone illicitly accessed your premises or cracked into your computers to get the information, this is trade secret infringement. If the trade secret holder in your organization leaked it out, to external parties, that's trade secret infringement. But if someone legitimately came up with the same thing, okay, without any legal breach, okay, you can stop that person of using it. Okay, for example, the Coca-Cola formula, if you go do your research and come up with the formula and you find it, and Coca-Cola would lose the protection over the trade secret protection over this formula. But they've taken a bet that no one can reverse engineer it due to the chemical complexity or the technical complexity of doing so. Okay, so this is the balance here, and it's very important to remember this balance between patents and trade secrets. When something can be reverse engineered, you cannot rely exclusively on trade secrets. So this is some fair and unfair commercial practices with respect to trade secret. As I mentioned, and we mentioned already this, illicit inciting employees, for example, to illegitimately take the information and give it to you, even if you incite them to do so. This is a breach. So it's not only the employee who is taking and stealing this information, but also someone external who is inciting him to do so, or giving him a bribery to do so, or someone using fraudulent means to get it through, for example, cracking a computer system, theft or espionage, for example. Okay, or through an illegal disclosure, for example, in the breach of contractual clauses of confidentiality. That's trade secret infringement. And that's the designs we've discussed it. We'll not spend more time on that. This is a small example of industrial design, again, by PayPal, to protect a graphical user interface. Now I'll hand over to Martin to discuss some aspects with respect to data protection and software licensing.
Thank you very much, Ahmed. We've just got a single slide on this. We want to pull out some key issues because we're in an interesting space right now. Traditionally, financial institutions have built a lot of their own technology. They've supported quite large development teams. They've gone through all of the aspects that Ahmed's been talking about in terms of protecting IP. What we have now is a rich and really growing ecosystem of FinTech vendors, really focusing in on the digital space, where financial institutions are very much focused and are building their businesses, both in the regulated and the unregulated sectors. And that's really changed a lot of the dynamics in terms of how financial institutions are going to market with FinTech solutions. And that's what the first point talks about, where we're talking about build, license, or buy. And we're seeing financial institutions making decisions around that, whether they build it themselves, which of course comes with all of the IP protections and everything else that we've been talking about on this session, but it takes time. And a lot of financial institutions don't have time right now. They're being challenged by disruptive entrance into the market. The digital banks are coming in, they're building very quickly. We're seeing traditional financial institutions competing with that, looking to roll out new products, new services in the digital space in particular. So then we see financial institutions looking at actually buying in those FinTech solutions. And when we say buy, we mean buy the companies themselves. More though, we're actually seeing the financial institutions licensing in FinTech products. And there's a couple of reasons why they're doing that. A lot of the FinTech products out there at the moment are very much plug and play. What I mean by that, they're off the shelf, they're ready to go. They've been created for a particular use case. They may need some limited configuration, some limited customization to meet the requirements of the particular banking customer, but the banks can get these in and get them up and running a lot quicker than building themselves. So that takes us into the software licensing process, really in terms of the financial institutions licensing these FinTech products from the FinTech vendors. And that takes us to the second point, which is the challenges of the FinTech procurement process. Because we've seen a real shift in how financial institutions procure now. And one of the key areas is in relation to the type of vendors that they're dealing with. Because this is where before we'd often see banks working with very large technology vendors who had very large portfolios of products, often doing a lot of bespoke development. And we'd see the banks taking a lot of the IP over. They would be owning the IP. A lot of that's changed now. The banks don't have time to go through long procurement cycles, to go look through long contract negotiations. Plus, they've got a whole variety of options now, where before they had to build it themselves, they can go and choose from 5 to 6 different vendors offering a specific fintech product. Now, that means that they're licensing those products in, those fintech services in. But the challenge there actually is that the fintech vendors are very different types of technology vendors. They're often early stage, kind of high growth entities, and they take a very different approach to the procurement process. So things that the banks are able to secure from other technology vendors traditionally when they were building their own solutions and getting technology vendors to support them on that, they're not getting that now. So actually the terms and conditions that the banks are securing are often a lot different. They're often a lot more supplier, technology vendor friendly than they have been, which of course raises issues for the financial institutions because they're building products and services on the back of this technology. And the terms that they're signing up to often place there's a number of contract risks there. From the vendor perspectives, the vendors, of course, are pushing this because the vendors are trying to grow their business. They're not giving their IP rights to the financial institutions. They're looking for very limited IP licensing terms. They are holding back a lot of their IP, where before you'd see that IP transferring to the financial institutions because they're growing their business. They're looking for valuations, IPOs, exits, future acquisitions. They're holding a lot within. So actually, as we talk about the procurement process, it's becoming a lot more difficult for financial institutions. And it's quite a challenge for those financial institutions' procurement teams because they've really been used to procuring in a very different environment. The next point we talk about is innovating fast. Whether you're a financial institution and you're building the fintech product yourself, or you're a fintech vendor and you're building your product and you're selling it into the financial services space, you're balancing speed against protection. And really what we mean by that is you've got to get your product out fast. There's a lot of competition in the fintech technology vendor space. You find a lot of vendors working on very similar solutions. That means that vendors want to get their products out fast. And there's a balance that they need to take with IP protection. And one of the things we often see is that sometimes speed takes precedence over protection. We want to get out to market, and that's a dangerous position to take. And that's where they need to be engaging, say, for example, with lawyers like Ahmed and myself to really talk through how they do that. Because whilst they need to get their product out quickly, they want to get deals done with financial institutions who are looking for these products and services. They also need to be thinking long-term about the value that they need to be protecting. We also, in brackets, we ask about open source software, and we're asking about that for a specific reason, because a lot of these products are being built very quickly. They're being built on the basis of open source software, third-party software, a lot of code that's coming in from particular software libraries. The fintech vendors are pulling all this together and getting these products out quickly. And financial institutions need to understand how the fintech vendors are building these products. What code are they using? Do they have all the rights in that code? Because they're pulling on lots of different things. This is not just a whole lot of software developers writing code from scratch. They're pulling from lots of different places. And the vendors need to be aware of this as well, because of course they need to have all the rights required to be able to put their products onto market and continue to maintain and develop these products. Fourth point is data. Fintech products and services are data heavy. They are processing huge amounts of data. We work in an increasingly regulated environment, not simply on the financial services regulation side, but on the data protection regulation side. These fintech products need to be built to be compliant with that regulatory environment. They need to be built to meet the financial institutions' regulatory obligations. And those obligations just keep getting more and more. You watch what's coming out of the UAE Central Bank, for example. There's a lot out there that financial institutions need to be complying with from a data protection position. Ahmed talked about the kind of disruptive fintech innovations that are coming on. Artificial intelligence, machine learning, biometrics, virtual reality, blockchain particularly. These all carry with them real challenges from a data protection position. As fintech vendors build their products, they need to be thinking about the regulatory landscape. You know, they want to be using blockchain, they want to be using AI, they want to be using other disruptive technologies. They are incredibly sought after in the market. They offer great value. They differentiate the product, but they need to work from a regulatory position. There is no point developing a product and then trying to sell it to a financial institution if you can't meet the regulatory requirements. For the financial institutions, of course, they've got large obligations under these regulations in relation to data. They need to be able to manage those. They've also got to be able to get this data out when they need it. They move between vendors very fluidly. It's a very agile environment from an IT perspective that they build. They need, a lot of this data is held on the cloud. These fintech products are cloud-based solutions. The financial institutions need to understand where this data is. Their contracts need to be clear who owns the data, and they need to be able to get that data out of these fintech vendors. It's a very important area that we work a lot with our clients on. Last but not least, as fintech solutions are built, of course, they're becoming increasingly the focus of cybercrime. For obvious reasons. These are things that are rolled out quickly by financial institutions. These become, as I say, cybercrime operatives are looking at weaknesses within these solutions. The financial institutions are really focusing on cybercrime. They're placing lots of obligations on the fintech vendors to make sure that their products are robust. From an IT security perspective, the fintech vendors really need to be focusing on that, making sure that their products, as they build them, really are able to resist what is an increasingly aggressive cybercrime environment. Those are the 5 points we wanted to touch upon. Ahmed, I'm going to hand it back to you.
Thank you very much, Martin. So for the reasons highlighted by Martin, we see as well a lot of collaborations today between financial in the space of developing the financial technology. So financial institutions, of course, they have their know-how and their experience in the financial sector, and technology companies, they have their experience and qualifications in developing technologies fast. And they are increasingly, for all the challenges Martin highlighted before, they are increasingly finding mutual interest of collaborating together in order to develop these technologies. So financial institutions are making, many of them taking the approach of working along with technology companies to develop financial technologies. And then they agree, of course, together on the ownership of IP rights and on the commercialization side of things. So there are a couple of things to keep in mind here when you are collaborating with another entity for developing a financial technology. Confidentiality clauses are extremely important. Of course, each party is disclosing some confidential information to develop or move forward in that project. It's important in the agreement to take this into consideration and to have confidentiality clauses to secure or to make sure the expectations of the parties are to keep the information confidential within themselves. Ownership rights, IP ownership rights are very important to take into consideration. So when you develop the technology, who owns the IP right? Is it joint ownership? Is it the ownership goes to one party or the other? And of course, based on the ownership rights, how who will be assuming the costs for IP protection as well. That's very important to take into consideration and to be part of the agreements, and the rights and obligations, of course, of commercialization of the end product as well, which needs to be discussed and agreed on. in the agreement in addition to the licensing and commercialization terms. This section is about acquisitions. So for the, I think we're out of time. We're just skipping, but we've discussed. I mean, you need, when you acquire, to be very careful to do your due diligence. We see companies acquiring, technologies without a lot of due diligence, which is very dangerous. So you need to do your due diligence from the legal perspective and as well technical perspective to see if that technology you're paying that amount for is from the IP perspective, is whatever allegations being done with respect to the IP this company holds or associated to that financial technology. Are these rights really existing? Are they valid? What are the scope? What's the scope of that IP protection? Is the scope slim, or is it a wide scope of protection? Because the wider scope of protection you have, of course, the more competitive edge you have, the more difficult for others is to design around your technology and come with a competing technology or a product. So all of this needs to be assessed, which will provide you with more clarity on the assessment of the transaction itself. So to minimize the risks, of course, for disputes, you need to protect your technology. You need to make sure that it's protected, it's well protected. And from the contractual perspective, you need as well, whenever you work with entities and even internally, put confidentiality clauses, for example, we discussed internally with the developers, have agreements with them as with respect to the IP ownership, very important. For R&D agreements, also you need to have clear clauses with respect to ownership, to commercialization, and so on. So when you take the proper means, to put things into order from the protection perspective and the contractual perspective, you're in a way minimizing the risks for disputes, and as well you are preventing and taking measures if ever you get into a dispute. You would have been prepared, the field, in order to kind of have a more favorable position. These are generally the types of disputes we see: IP ownership, who owns the technology, infringement, of course, and contractual disputes, a lot around, of course, breach of confidentiality, for example, or a party continuing use after the termination of agreement, and so on. So these are the key takeaways. It's very important to consider the IP protection, the different tools, along with the contractual measures as well. And it's important to balance the speed, as Martin mentioned, with the protection. Well, there are strategies we can adopt to expedite the protection process while you're developing fast and going to the market quickly. And during the R&D agreements process as well, this needs to be handled very carefully from the legal perspective for, to make sure that your expectations from the business perspective are met from the legal perspective as well. Thank you very much. And this brings an end to the webinar. If you have any questions, please feel free to reach out to Martin or myself. Have the contact information in the screen below. I don't think we have a lot of time for questions. We're already out of time. However, we'll be very happy to answer any questions you have offline if you reach out to any one of us. Thank you very much and have a wonderful day.
Thank you very much.